Hi, everybody. Thank you so much for joining us today. I'm Michelle Morris from Consolidated Planning Group, and today's webinar is going to focus on the Special Needs Trust. It is so important. If you have a loved one with any kind of disability and they are receiving any benefits, they really should have a special needs trust to help protect those benefits. And Julia is going to be talking with us today about what this does for you and why it's so important. I have a few things to go over before we get started. Yes, we do record all of our webinars. We present live, but then we record them as we're going and we put them on our YouTube channel. So if you want to come back and watch later on, you can certainly do that. Also, you will receive an email later today that has a link to the YouTube channel and a copy of the slides from today's webinar. You only get that if you register. So if you are watching on our YouTube channel already, or you're maybe listening to this on our podcast, and if you want a copy of those slides, just email us, contact@cpgairs.net, and we will go ahead and get you a copy of the slides if you haven't registered for this webinar. We are in webinar mode, which means that we can't see or hear the participants, but that's what the chat box is for. Any questions or comments you have, we would love to have them put into the chat so we can answer the questions. We've also received some questions ahead of today's webinar, and we double checked that the answers will be provided in the material, and if not, we will address those specific questions for you. So who is Consolidated Planning Group? Why do we do this and why should you listen to us? Let's start with that. First of all, we are a holistic, special needs focused financial planning firm. We are located just outside of Houston, but because of the internet, we are able to serve families all across the United States. Most of the meetings that we have with families are virtual, so we can certainly help you wherever you are. We have been serving families for 30 years, over 30 years, actually, with life insurance and investments. And about 10 years ago, we began focusing solely on helping the special needs community. We are parents of individuals with differences. We are chartered special needs consultants, members of the Special Needs Planning Academy, and we are National Certified Social Security Advisors. We take this very seriously, but we also live it day in and day out. We know what you're going through. It's kind of rare that we do because out of 263,000 financial advising firms across the United States, fewer than 200 focus on special needs planning like us. It's less than 0.1% all the financial planning firms in the United States who truly are experts in this area. So you're in the right spot. Families come to us for things like lifetime care planning and thinking about how to protect your family if something goes wrong. We talk a lot about transition planning, what happens after high school, and how to prepare for that, as well as how much money needs to go into your special needs trust for the future care of your loved one after you're gone. We talk a lot about state and federal benefits, and we help families make sure that they hold on to those benefits because that's a big part of your financial future. And of course, we're here to advocate for you and to educate you. Um, as parents, we have this unique perspective, knowing what needs to be done and what you're going through. We also understand the legal side of things, the financial side of things, and how all of these benefits work together. So, some things, some advice that we want to give you before we turn everything over. Um, Things that you need to think about is that it's really important that you start planning for the future now. Doesn't matter what you've done already, what you haven't done. We're not going to, you're not going to be in trouble or you're not going to be laughed at. You shouldn't be embarrassed about what you have or have not done. But what we talk to families about is the fact that if you start planning now, you're going to have a longer runway And you're going to be able to make small adjustments that are going to have a big impact on your future. Think about what's going to happen after high school in terms of educational options, residential and transition and day programs, and vocational options. There are work programs that are going to be very beneficial. And just think very carefully before you assume that a sibling is going to be able or willing to step into the role of caregiver. That can create friction on both sides of that equation. So families often think that that's going to be the easiest, smoothest path, but it isn't always. So I do see already some questions and comments. Tamara is saying that she is hearing a lot of audio feedback. I'm not doing anything different today. So Tamara, I don't know if there's a setting that you need to adjust or if if everyone is okay. All right. And then I also see a question, having a hard time convincing my husband that we need this and we need an ABLE account. So today's webinar is really going to help answer that question and why and how you use the money in the Special Needs Trust and why it's so, so important. So today we have Julia Pullin from Rosenblatt Law Firm to walk us through your questions and the information about the Special Needs Trust. Julia, thank you so, so much for being here with us today. And to all of the participants, whether this is the first webinar with us that you've heard or the 41st, I'm glad you're here. Julia, would you take over for me?
Hi there, good afternoon. It's an absolute pleasure to get to be here today and be able to speak with all of you. I am a senior associate attorney with the Rosenblatt Law Firm with offices in San Antonio, Texas, and in Houston, Kingwood, Texas. And we practice in a wide variety of areas, but I personally practice in estate planning, guardianship, elder law, Medicaid planning, and special needs planning and probate. I'm a board certified attorney in estate planning and in probate. And we are in the Rosenblatt Law Firm has been around for a bit over 20 years now at this point. Now, I'm very passionate about special needs trust and special needs trust planning because I want to make sure that, these people, everyone is taken care of. I have several friends and family members who have children with special needs and are going through trying to qualify them for benefits or figure out their care. So this is something that's very close to my heart. Now, a special needs trust is a special trust that is allowed by the government. It's also known as a supplemental needs trust. Sorry, my light's on an auto timer there. And it allows for a person who is either qualified for or currently receiving needs-based government assistance to receive either gifts or inheritances or income without being disqualified from those benefits. Now, this is allowed under federal law. So whenever we talk about first party, third party, pooled trust, there's a few different types of trusts that exist. These are all really allowed under federal law. Now, I am currently only licensed in Texas, so a lot of my information will be Texas based. So especially whenever we get to the Medicaid portion, that will be more Medicaid Texas focused. So I have a couple of programs that I'll do a quick overview for. I'm sure that you are familiar with these programs and the benefits, but it's very clear that if you're trying to receive needs-based assistance, either based on disability or low income, you really have to have very, very low amounts of assets and income to do that. Now, with Medicaid, so I have in Texas, so while this is a federal program, it is tailored to each state. So I've had people ask me, what's the best, way to get Medicaid? I say, move to California because honestly, that's the best place to get Medicaid. You have the most permissive ability to qualify there. But essentially, if you're wanting to stay in Texas, which, I was born and raised, I love Texas, you have to have very particular income and asset requirements. So income is what's coming in each month, coming in directly to you, your name's on the check. That would include things like, of course, employment income, pension, alimony, child support payments, any retirement benefit payments, all of that, whatever's coming in directly to you, Social Security, that's all counted against income. And so you have to have less than $2,982 in income per month for an individual, or 5,964 for a married couple. Sorry, it looks like that number's a little cut off there. But basically, you just cannot have any more than that. And of course, because it's the federal government, they're not fair. They account it as gross income, not net income. So it's pre-tax income that you're getting, not what actually arrives in your bank account. Now, you also can only have a certain amount of countable assets, and that is what you actually own, besides what you're receiving every month and ideally spending every month. So the countable assets would include everything but basically a house and one car per driving member of the family, certain small life insurance policies, certain personal property, but basically everything else that you might have is going to be counted against this number, which would be $2,000 for an individual or $3,000 for a married couple. So very, very tight restrictions in Texas for qualifying for Medicaid. We also have something called a look back period where if you make transfers within 5 years of applying for Medicaid, they can count that against you. And even if you are able to get on Medicaid, they can say, well, you made this, $10,000 gift 3 years ago, so now you can't receive Medicaid for an additional 2 years. So these are all things definitely to be aware of whenever you're looking at qualifying for Medicaid. Now, there's also supplemental security income, or SSI, which is additional income paid to low income individuals with disabilities, where you have to be at least 65 or older, blind or disabled, and have limited income, limited resources. So it is very similar qualification to Medicaid, where you can only have $2,000 countable resources for an individual, 3,000 for a married couple, and less than $2,073 income from work each month, although they have different standards for people who are blind or not blind. And then finally, SSDI, or supplemental security disability income. So this is allow for people who are not able to work because of a disability, either because they've already worked in jobs covered by Social Security in the past, or if they're under age 22 or had a disability before age 22, then they can receive that based off their parents' Social Security. Now, these are monthly payments that are made. And what is interesting is that there is no asset requirement restriction for SSDI. So what you own is not counted against you, but there is the income restriction, which I have here is the difference with the blind and the not blind. Basically, you have to meet this definition of disability with Social Security. They have a whole broad list of conditions, and be able to actually get in line and finally receive that. Now, whenever I talk with parents or family members wanting to take care of their child or their loved one, maybe they have a sister who's on Medicaid that they want to leave some money to, there's basically three different ways that that can be managed. The first way, which is unfortunately the most common way that I see, is completely disinheriting that special needs individual. So it's very common that I'll have parents come in and they will have, say, 3 children, and one child is on Medicaid and they're going to need that long-term care support. So they're planning on leaving everything to the 2 other children and completely cutting out that special needs child. But that's not something that I would recommend, because a lot of the time these parents will leave that money directly to the other children to be used for the benefit of that special needs child, but not using a formal trust to do so. So first of all, we are really counting on that child to actually hold up their end of the promise to take care of their brother or sister, because that might not always happen, and they might over time want to use the money for something else, and that's their money at this point, so there's not any recourse available for the special needs child. And then also, what if, maybe they do manage the money properly for their brother and sister, but then they go through a divorce or they're sued for some reason for being in a car accident, and now suddenly their assets are subject to judgment. Well, then that money is also gone. So the best intentions don't really end up working out, unfortunately. There's also the other flip side of the coin is leaving that individual with everything. So essentially, knowing that that individual is going to be disqualified from getting any additional benefits until all that money is spent down, and then they have to get back on those needs-based government benefits. And so that's also something that I would not recommend as well, because then at a certain point, all those benefit, all those money in the inheritance could be spent down. And now everything's completely different. We might not have as many options as we had with pre-planning. So my third choice would be diligence, which is engaging in pre-planning, talking with an attorney to be able to design your estate plan so that things are going to be taken care of for your special needs child or for your special needs sibling or anyone else who might be in need of needs-based government assistance or receiving that currently.
Julia, we do have a couple of questions I just wanted to address before we get too far away from talking about those. I
Mhm.
know some of these you will definitely get to, but you mentioned life insurance counting against Medicaid. Uh,
Right.
so that's only if policy is if the child is the beneficiary of their own policy, right? Or if there's a
No, it's
cash
if
value.
the person who's applying for Medicaid, they own the policy essentially, and it
Right.
has a face value of more than $10,000.
So if it's the parents own the policy on their child, that would not count against the
Correct.
child.
That would not count against the child because the child cannot actually access that money or cash out the life insurance policy. Basically, Medicaid is making sure that you can't, they're looking at all available resources that you have. And if you could possibly cash it out or use it, then they're saying, well, do that first and use that
Mhm.
money, spend it down, and then come to us, essentially.
Right. And then there's another question. Chris is asking if you can receive SSI and SSDI at the same time. And are certain circumstances where you can.
Yes, you can
Typically,
receive
and
both.
yes, typically an individual would switch from SSI to SSDI because the SSDI amount is going to be more. But if
Mhm.
it's not, you might be able to get both at the same time to crew up the payment that you're getting.
Right.
All right. Do inherited life insurance benefits count? Well,
Yes.
that's what needs to be left
So
to the.
yes, and that's something that is a huge problem that I see a lot where that person who is receiving Medicaid or needs-based assistance, or if they are going to be qualified for that, or if they're incapacitated and they're named directly as a beneficiary on a life insurance policy or on a 401k, an IRA, a bank account, well, then that money now is due directly to them. Someone's passed away, that check's going to be written out to that individual, and they're going to be kicked off of benefits until that money can be spent down. So there is some things that we can do to react to that, which would be such as a first party special needs trust or supplemental needs trust. Now, on this slide here, you'll see that there are generally three different kinds of special needs trusts, such as a first party special needs trust, third party special needs trust, and a pooled special needs trust. And I'll kind of give a broad overview of each one, how they work, and what circumstances they would be used in. So for the first party special needs trust, this is what happens when, like I was just talking about, the special needs beneficiary is named directly on a life insurance policy as receiving the money when someone dies, maybe a parent. and then parent has died. So the check is on the way. We have money that is due to that child, or that child is entitled to receive that money. Same thing if they are earning money from a job, or if they have judgment from a lawsuit. So, for example, if there's a wrongful, any sort of lawsuit related to their disability, or if they're entitled to reimbursement from someone, all of that would count against them as assets or income for them. So there's not any way we can change that. I've had people ask, well, can't I just change, I call the bank and ask them to reissue the check to me? And I'm like, no, we can't. We kind of have to we have the situation now, the money's coming, and we have to figure out how to receive it. I've also had people ask, well, can't we just disclaim it or assign it to someone else or decline the money? No, because Medicaid will say, oh, that still could have been yours. So even if you didn't actually receive that money, we're going to count like you did, which is unfair. So basically, if this is the case, then I would recommend setting up a first party special needs trust. Now, this can be created by the special needs person themselves, or a parent, grandparent, legal guardian, or agent under power of attorney, or a court. So it can be created by different people. The beneficiary must be under 65 years of age and classified as disabled. So unfortunately, if you are over the age, or if you are over age 65, if you're 66, you cannot create a first party special needs trust or be a beneficiary of a special needs trust created for you. So these are the big requirements: that you have to be classified as disabled by the Social Security Administration definition, have to be under 65 years of age, and this trust must be non-revocable or irrevocable. So it means it cannot be changed once it's created. It is set in stone. Now, what's great though about this trust, even though there are limitations, whatever money is received into that trust for the beneficiary, none of it is counted against benefits. So it does not count against Medicaid or SSI or SSDI or any other needs-based resource program. It is not counted against them. So whatever they receive, it's completely protected. And we would have to set this up in a way where the beneficiary have no ability to control it, because we're setting this up and we're saying, okay, we have this pot of money over here, beneficiary over here, they have no ability to go into that money and demand it. They can't have resources from it. They have no control over it. We can't dissolve it. We've created it and it holds this money, and we have these requirements. Now, the only thing is that there is a downside though with a first party special needs trust, is that there must be a payback provision to the applicable state Medicaid program. So while that special needs trust can hold as much money as you want to put into it, there's no limit in how much money you put inside of it. It won't count against the beneficiary. Once that beneficiary passes away, then Medicaid can come in and say, okay, we spent $100,000 over this person's lifetime for benefits and supports and services, and we need to be paid back. So on the next slide, I actually have like a little graph that talks about the process of how this would be set up. So first, we would come into a situation where, okay, we need this special needs trust to be created because we got money coming to the beneficiary already. It's on its way. We can't get rid of it. So whenever we receive it, instead of it going directly in the beneficiary's name, we put that in that first party trust. Now, once that first party trust is created, it's held in this separate trust like a bank account. It can hold property, it can hold investment accounts, and managed for the benefit of that beneficiary during their lifetime. And I'm going to get into distributions from special needs trust later on, but basically the trustee has discretion to make distributions and manage things for that person's best interest. Now, once the beneficiary passes away, that's when the state estate recovery program comes in. In Texas, it's called MERP, Medicaid Estate Recovery Program. And they'll come back and make a demand, say, hey, we are owed, $200,000 for supports and services we paid during the person's lifetime. So they would get reimbursed for that. Now, if that amount of money is more than what's left over in the trust, then it's fine. They're not going to come after you personally because that's pretty much they can only come after the trust or whatever the beneficiary owns that's going through probate potentially, which is kind of in a different branch. But really, it's okay if they owe more than what's left over in the trust. You're not going to be personally responsible for that. And then if there is money left over, then you can have that paid to what's called the remainder beneficiaries or whoever's set up to receive that money once your child passes away and you want to have that go to, say, their children or their brothers and sisters or other family members or to a charity potentially. These are all things that can be set up. Now, on the other hand, there's something called a third party special needs trust. So this is something that is set up by anyone else other than that special needs beneficiary. So whenever we're talking about a special needs trust created under a will, for example, or created under a trust, these are usually a third party special needs trust. It's set up to catch that money before it's going to go to the beneficiary. So think of it like, we got the baseball coming to the beneficiary and the beneficiary is going to receive it, but then someone catches it before it gets there. So essentially that's never coming into their name. So we are able to intercept it in time by getting this set up in advance. So there's nothing coming to that beneficiary. Now, this can be set up by a parent, a grandparent, a friend. You could have, the King of England set this up for you. Whoever in the world can set this up for someone else. And there can be multiple special needs trusts set up. Anyone can create one for the benefit of that beneficiary. And also, there's no age limit for that beneficiary. So we don't have that 65-year-old age limit. We don't have to worry about the payback provision either because this was set up. The beneficiary was never entitled to that money. They were never receiving it in the first place. They essentially never had an option. So once that beneficiary passes, then there is no way for the government to come in and get reimbursement. So essentially, whatever's left over goes directly to the remainder beneficiaries.
Yeah, there's a question in the chat box that, kind of explains this perfectly. Can the beneficiary put their income into the third party special needs trust? No, the first party, it's like back in high school literature class, first party perspective is that's your own money. If they earned it, if they were given directly, they were given that money, that's their money and it has to go into the first party trust. The money is left to the trust, that's third party. And so that's very different, is where the money comes from kind of dictates where it needs to go.
That's a great answer. And I just want to piggyback off that. So once this third party trust is set up, usually upon the death of parents or grandparents, whoever is setting this up, the beneficiary cannot add their own money to it. That first party, what they own or what is entitled and due to them, must be completely separate from the third party trust. We cannot mix them together. Because if we do, then first of all, we might have an invalid trust on our hands. So now everything's suddenly counted against the beneficiary, or it might all be treated as a first party trust where all the money has to be paid back to the state once that beneficiary passes away. Now, I see a question I had about setting up a bank account for a special needs trust set up in a will. Now, that's something that I would mention. That's something called a testamentary special needs trust or a special needs trust that only comes into effect once someone passes away. So this special needs trust is not currently in effect right now. It does not have any control over anything. It does not own anything, and it will not own anything until someone passes away. So you cannot set up a bank account for that right now because it's not in existence right now. The only way that you could create and open a bank account for a special needs trust now is to create its own trust, what's called an inter vivos or standalone trust that's effective now while you're alive, and you put money in it now, kind of like a savings account. So I have this chart here, and it is similar to the first chart I discussed for the first party special needs trust, but basically someone else creates this trust for the benefit of the special needs individual. That money is held for their benefit once it's created. And then once that individual passes, then that goes directly to the remainder men or the remainder beneficiaries. So very powerful planning here. And I strongly recommend that anyone set up, if they set up a will or a trust or any kind of estate planning, look into this third party trust because that can really, really be powerful for the special needs child. Now, there is a pooled trust. Now, this is kind of used in situations where we don't have a lot of options, such as if we do have, and I'm going to use a real example for me. Um, I had someone call me, a few years ago, and they said, okay, my sister is 67 years old and she was named as a beneficiary on a life insurance policy for a parent. Parent just died, and now she has $50,000 coming to her. So she's on Medicaid. She's in a long-term care facility. What do we do? Well, the problem is if she was under 65, we could create a first party trust and put that money in there. But now we can't do that. So we would have to look at the other options. Now, one option would potentially be an ABLE account, which I'll touch on a little bit later. But in this case, I think that they could not set it up because of the current laws. They were too old to set up an ABLE account. Also, so we would basically just either looked at having to spend it down and get disqualified for Medicaid until you spent it down, or set up in a pooled special needs trust. So there are several nonprofit organizations and charities. One of the most well-known ones is the Arc of Texas, located in San Antonio, Texas. And they are a charity or a nonprofit that professionally manages special needs trusts. Now, there would be individual trusts set up for each individual beneficiary. So there could be many hundreds of special needs trusts, but all the money is pooled together for investment purposes, so it can have a better return. So this can be a good option if someone receives money, if they're over 65 and they receive money, we could transfer that potentially into a pooled special needs trust. There might be a transfer penalty though for that. And in this case, in Texas, there is. So kind of in a rock and a hard place. Um, in fact, in that circumstance, I think I recommended purchasing a vehicle that was not countable, that so that the beneficiary could have transportation. So get that purchased within a month. That vehicle doesn't count against that beneficiary. Now, the downside though is that once the beneficiary passes, there is a requirement that the money be paid back to the state of Texas Medicaid program. But if, we have people who are nominated as a trustee and they're overwhelmed and there's no alternates named, they might want to work with a professional charity or a bank or someone to help them manage these trusts. Or sometimes a beneficiary might not have anyone, maybe their family members are all too old or have died or incapacitated. And there's like one remaining person and they're like in their 90s. They're not going to be able to do things much longer. That's when I would suggest moving it to to a pooled special needs trust so that that
Mhm.
money can be managed for that special needs beneficiary, even though people have passed on.
There are a lot of questions in the chat about, what money goes where.
Mhm.
Child support. Child support needs to go to a first party trust because after age 18, that is considered the child's money.
Yes,
Can you leave IRAs and 401ks and everything else to the third party trust? Yes. And life
yes.
insurance and houses and
Mhm.
other assets can be left to the trust.
That's right.
Basically, one thing that I find that a lot of people get confused about if they're not part of this financial world and they haven't done it before is that the trust is basically the title that you're taking that account or that money under. So maybe the bank account is listed under Julia, or it's listed under me, or it's listed under the trust. It's not the trust is the place where you put it, it's just how you're holding those assets. So sometimes people get confused and they think like a trust is a location. It's not,
Mhm.
or a kind of account. It's the title that you're taking that account under, right?
Right. It's kind of like the cloud, where you
Hmm.
don't know where it's located. So it can be located in many different places. And also, what's also to consider is that this money is titled, it's given to the trustee for the benefit of the beneficiary. So it's held in trust by this trustee, this person managing the money for that beneficiary for their benefit.
Yes,
So
and it does have a tax ID number. Yes.
yes, it does. And when that's created is basically whenever the trust is created. So if we're looking at a third party trust, an inheritance, if it's in a will, it won't be created until after the person who had created the will passed away. If it's an inter vivos one that's created now, you would get that EIN now, essentially.
Mhm.
I would suggest, so designating the ARC to manage the trust, you can just name them on there, but I would suggest reaching out to them. I would suggest contacting the ARC of Texas, visiting with them. There are also other, places that you can nominate as the trust. I know there's one in Travis County. So there's a few different options. It's mentioned on the state Medicaid website for pooled trusts, so you can look them up and contact them.
And a pooled trust, one thing that I don't love about it for the clients of Consolidated Planning Group is that you don't have a lot of control over the money. Whereas if you go with maybe a trustee, a corporate trustee, something like that can help you determine. So speak with your financial advisor about what a good option for you might be. And if your financial advisor doesn't focus on special needs topics, I know one that does.
Yes, exactly. And I actually work a lot with banks and financial institutions that do professionally manage these special needs trusts. So you can get it set up, and the bank is the one that's taking care of it. So the pooled trust is kind of a backup, essentially,
Mhm.
but it's good to have as a backup, especially if, say, the money is so low in value, it doesn't, the bank won't take it on what's in the trust. Or, like I said, everyone else is just gone. We want that to be continued onward. And really quickly, I'll answer this question I see for if one moves out of Texas and the trust is set up in Texas, does that affect things? No, it should not, because these trusts are set up mainly under federal law. Now, I will suggest talking to a lawyer in the state that you move to confirm that it's not affected, because also different states will have different benefits. And so, like if you're moving to California, you're probably entitled to a lot more benefits than you are in Texas. So definitely always recommend reaching out to a lawyer in that state. But that trust that's located in Texas, it should not affect anything, even if it's still located in Texas. Now, so for special needs trust, this slide should say who is the beneficiary. I don't know why I've been having some funky formatting issues when it came over,
Sorry.
but no, that's okay. So basically, there can only be one beneficiary of a special needs trust, whether it's third party, first party. It has to be that person receiving needs-based government assistance. You cannot have multiple people receiving that. So and if there's a husband and wife, they can't be beneficiaries of the same trust. They would each have to set up their own trust. Now, the distributions must be made for the sole benefit of the person of the beneficiary. Now, there may be certain distributions that can be made to maybe an aide who's helping the beneficiary in travel, recreation, day-to-day life, but really those distributions just have to be for the sole benefit of that special needs person. And also, sometimes banks, they like, well, I see there's remainder people here. Should I set aside some money to give to them? No, I would always put in something, no, we can even spend it all down as long as this is for my child. This is for my beneficiary. So for distributions, I've touched on it a couple times, but distributions from the special needs trust, the standard is supplement, but not supplant public benefits. So this is the phrase you're going to see everywhere, or the more common lingo, add on to, but don't take over or replace what the government's already going to pay for. So if the government's going to pay for something, great, let them. That's what we're doing. We've already paid this money in taxes, let the government pay it back. So you get whatever you can and have the beneficiary receive whatever benefits they might be eligible for. But if the government doesn't if it doesn't pay for something such as a dental procedure, well, then that's when the trust can come in and pay for that dental procedure or for additional therapeutic purposes or for holistic remedies or any other alternative medicine and things like that. The trust can pay for basically anything else that the government doesn't, as long as it's for that beneficiary. Now, only the trustee can manage this trust. Only the trustee can make distributions. The beneficiary cannot compel. They can't say, give me this money for this purpose. They cannot control the trust in any way. They cannot have access to the trust funds, and they cannot change the trustees. So a estate planning attorney will be able to help you with building in fail safes with, okay, if this trustee can't work, if they're not able to do it, then we have someone else who can nominate a trustee or remove a trustee in place of that beneficiary. So we're not violating these rules. Now,
Just
yes.
would you say that it's better to have like a corporate trustee or have a family member do it?
You know, that's a really complicated question. It really depends on family dynamics. It depends on, education of the family members' comfortability that they have with managing the trust. I have seen where it all stays in the family and everyone's super happy because they know, like, they're very familiar with the beneficiary and what their needs are. But I've also seen it go really far south where, there no one can agree on anything and they're worried that the money's being mismanaged and kind of the family's being torn apart by litigation. There's
Mhm.
also, so that's one side of things. On the other side of things, having a corporate fiduciary or a trustee is good where you have the ability to have this person who's bonded, first of all. So if there's anything that does go wrong, they have the money to reimburse the trust. They have to pay it back. They're held by a fiduciary standard, and they also have people looking over their shoulder. So there's more accountability there. However, the downside is, they don't have that personal relationship sometimes. And also, the cost a little bit more money than a family member does. Usually it's a percentage based on the trust asset. So just keep that in mind. I've also had a sort of blended family situation where we had the bank as the trustee, the person who manages the finances, but we also have a family member as a care manager. So they're able to talk to the beneficiary, advocate for their needs, and talk to the bank and say, hey, we need, these things, especially for a beneficiary that maybe can't advocate for themselves. So there's different approaches that we can take.
Perfect, perfect. So, a couple of notes from the chat. Yes, if you have a third party, but there's also child support, you're going to have both a third party and a first party special needs trust. Certain things go certain places. Anybody can put money into the special needs trust on behalf of your loved one. You just need to let them know what that tax ID number is, and then they can leave money to that trust if they want to give a gift, or if they want to set up their own. One person can have multiple trusts, but it does not have to be kept separate.
Correct. Absolutely correct. I will mention though, so if we are setting up an inter vivos trust, like a third party trust, we're setting that up and a lot of people are gifting into it. There will need to be a tax return filed, a gift tax return filed for each gift that is made to that trust. Now, ideally, there won't be any gift taxes that y'all would have to pay because right now, each individual person can gift up to $15 million under the federal threshold without paying any gift taxes. But each state will have its own different rules. Texas doesn't have gift tax rules, but you're going to have to check with someone in your state too. But just keep in mind you're going to have to report that gift. Now, whether or not there's going to be a gift tax depends on where you live. For allowable expenses from the trust, we had that standard earlier that we talked about supplement, but not supplant government benefits. And I've listed here lots of different allowable expenses that you can use. So you can see it actually covers a broad range of things, such as home repairs and improvements. I had someone who was able to install accessibility devices to renovate a home for the benefit of that beneficiary, add ramps, add better heating, add a walk-in tub, things like that. Non-grocery food items, transportation, such as paying for bus passes, a vehicle purchase, like I mentioned earlier, repairs and expenses, insurance, taxis, Ubers, entertainment, like if they want to go see the movie or read a book or join a club, they can have that ability to go out and socialize and engage in things that they're passionate about. Travel, study abroad, vacations, going to see family and friends, join the Special Olympics, pay for additional rent and utilities after the requirements for SSI have been met if you're on SSI, because keep in mind if you pay for someone's rent or utilities, that can reduce the benefit they ultimately receive. Medical equipment not covered by any government programs, clothing and wearing apparel, internet and cable, insurance, home care services, cleaning services, educational expenses. Yes, it can own a residence where the person lives. Just keep in mind who already owned that residence. Was it the special needs person? Or was it someone who wants that person to receive the house once they die? So, like if you have a parent, they want their child to live in the house once they pass away, they can put a third party special needs trust in their will. And once they die, then that can go directly into that third party special needs trust. And remember, whatever goes in that trust, not counted against that beneficiary at all. So it doesn't matter if you have, millions of dollars in that trust, none of it's counted against that beneficiary for government purposes.
But question, they are allowed to own a house
Yes,
regardless. It does not
they
have to
can.
be in the special needs trust.
Correct. Usually a homestead is considered a non-countable asset for Medicaid and Social Security. But, and it's a big but, so Sir Mix-a-Lot will be happy. The if a person dies and they have a property in their name and they were on Medicaid, then we got that MERP program
Mhm.
coming to take that house once that beneficiary dies through the Medicaid Estate Recovery Program. So usually whenever someone receiving Medicaid passes away, Medicaid is going to file a lien against the estate of the person that dies and whatever is going through probate. So we want to avoid that if at all possible. And by putting that in a trust, that avoids probate because you can designate who gets the house after that beneficiary dies.
Julia,
Now,
we've got about 9 minutes left. So if you could
okay,
explain
thanks.
on when you go through this slide, obviously you're going to talk about rent and utilities and shelter.
Right. So if someone else is paying for rent or utilities for a special needs beneficiary, then SSI is generally going to reduce the benefit that the person receives. So a lot of times we have parents charging their child rent or a portion of the utilities so that they can receive that increased benefit. I think it's between $200 and $300 that
It's a
SSI
third.
will give. Yeah, the third. So if SSI finds that someone else is providing that, like the trustee of a trust, then they'll reduce that benefit. But if there's additional expenses, maybe like an HOA fee potentially, the trustee could pay for that of the trust. Or landscaping services or a maid or things like that, they can come in and pay for that additional expenses related to their living situation. Other non-allowable expenses would be usually for grocery, food items, disbursements for shelter, like I was mentioning, the rent, utilities, things like that. Giving cash directly to the beneficiary, that's going to be counted against them directly. And don't purchase property directly in the name of the beneficiary. You know, we mentioned the house, they could potentially have a homestead, but big danger there after they pass away, then Medicaid can come in and take that house. So, you know, that's pretty much it. Other disbursements that would be qualified, covered by public benefits, as well as just general support, not special needs. But as you can see, there's a lot of things that can be considered special needs. Now, the trustee does have certain requirements like managing the trust as fiduciary. I mentioned that fiduciary as managing things for the benefit of someone else in their best interest, not in the trustee's best interest. Keep the beneficiary informed about what's going on, give them an annual accounting or annual statements explaining what goes out, what comes in, preserving eligibility for public benefits, and filing annual tax returns. So general advice for trustees that I have, biggest one, read the trust, read it and keep detailed records, work with an estate planning attorney or special needs attorney that can explain to you what to do, manage funds prudently, familiarize yourself with laws, only make disbursements to that beneficiary, not to yourself. And just always seek the advice of legal counsel. Now, really quickly, I don't have a slide for this, but I saw there was a couple of questions about ABLE accounts. ABLE accounts are fantastic. They are great savings accounts that can be used for special needs beneficiary, and they can be established now. The age was raised from 23 to 46. So you just have to have that disability before you were 46. Now you cannot have more than $100,000 of lifetime contributions to this ABLE account for SSI. Or if you're not on SSI, maximum lifetime contribution is $500,000. But the problem is that disbursements can only be made for qualified disability expenses. And also there is a payback provision once that person dies. So whatever's left over in that ABLE account, the state Medicaid program can get reimbursement from that too. So if you want to find out more information on ABLE accounts, I recommend that you go to texasable.org or your state's ABLE program. And
Call
yes,
us at Consolidated Planning Group.
yes, call them.
We can do that. Yes,
No,
we
you
can do that.
cannot move money from the first party trust to the third party trust. You cannot. They're completely separate. All right, turning that over to you, Michelle.
Oh, yeah, just a couple of slides. You know, we do these webinars every week. Click to pre-register so that you can get a copy of the slides when we send them out. Plus, you can send in your questions. You have the link ready to go. It just makes things easier. We do offer a free initial consultation to anyone who comes to our webinars. You can use this QR code or call or email the office to schedule, or you can call or email me directly. And I'm putting my number and email address in the chat box again. So we want to, give you some free advice and help you out and talk to you a little bit about what we do and how the process works to work with Consolidated Planning Group. So here's a great question, and it is related because it's so important. How many guardians can a disabled person have? And maybe the rules are one way, but my opinion is it should be one, maybe with successors lined up behind that one, but it should be one because if there is ever a dispute, then the guardians don't really matter so much. The courts will make the decision about what happens to your loved one. Isn't that right, Julia?
Yes, the only time that courts really allow for more than one person to be guardian is if they're married. So, like if we have the parents of a disabled person applying to be guardian when they turn 18, that's very common. That's something that I do regularly. But however, if they're potentially going to be divorced or they already are divorced, then probably not, because the court will not grant it if they're already divorced. And if there's tension there, then or potential divorce in the future, then that's not a good idea.
Yeah, yeah, that can get into a very sticky situation and cause, dramatic issues with your family. So just be careful with that. Thank you so much, Julia, for being here today and for answering all of our questions and teaching us about the Special Needs Trust. If anybody has additional questions for Julia, we will send out contact information in the email that you get later on today. You'll also have these slides and you can look up Julia. You can reach out to us. We'll connect the two of you. Um, we are happy to help and answer those questions for you. So hopefully that if you need anything, you'll reach out to us. Again, have a great, great week. Thank you all for being here with us today. Reach out to us for your questions and have a great week. Bye, everybody. Thank you so
Bye.
much. Thank you, Julia.
It's been a pleasure.